we have one of the most popular speakers that ever comes to cattle raisers events, and that's Tiffany Dow-Lashmet. Tiffany has served as an agricultural law specialist for Texas A&M AgriLife Extension Service since 2013. Her work focuses on legal issues impacting Texas landowners and agricultural producers, including leases, water law, oil and gas law, pipeline easement negotiation, estate planning, and landowner liability. She travels the state speaking at various meetings and conferences on these issues and has published several law review articles, extension fact sheets, magazine articles, and newspaper articles on these topics. She also authors the award-winning Texas Agriculture Law blog, so please go subscribe to that if you can, because it's really good. It's been recognized as one of the top 100 legal blogs in the nation by the American Bar Association in 2014, 2015, and 2016. Tiffany hosts the Ag Law in the Field podcast, which was included as one of 20 podcasts on the American Bar Association Web 100 in 2018. It's also excellent. Tiffany was named State Specialist of the Year in Texas Agriculture by the Texas County Agricultural Agents Association in 2016 and won the American Agricultural Law Association Excellence in Agricultural Law Award for Academia in 2019. She's licensed to practice law in Texas and New Mexico. Tiffany grew up on her family's farm and ranch in northeastern New Mexico between Tucumcari and Logan. She now lives in the Texas Panhandle with her husband and 2 children. And Tiffany's just a joy to have. And so we're certainly thankful to have her here with us today and for taking the time out of her busy schedule. As you can imagine, she's quite popular. And so we appreciate her taking the time to be here with us today. And her topic is landowner liability, and one that I think many of you will find a lot of value in. And so with that, Tiffany, I will turn it over to you.
Sounds great. Thanks, Stacy. Can you hear me okay, and can you see my slides?
Yes, on both accounts.
Perfect. Okay, we will get going. Thank you for having me. I always love to speak for TSCRA. They do such great work and always have great educational programs, and so it's always an honor when I get asked to come and speak for them. We will start out the program. I always like to admit up front to everyone that I am a lawyer. I know that nobody likes lawyers, okay? So let me just give you a little clip of what my family members have to deal with me being an attorney.
Okay, what's your name? Good, where are we? Why do we have that sign?
So those poor kids are dealing with a lawyer mama who is worried about things like landowner liability issues and how to protect us. And so you guys are going to get to deal with that today too. To get started with the program, I have to give a disclaimer when I speak, and that's basically I'm a lawyer, I'm not your lawyer. I cannot offer anybody specific legal advice today. If you need that, you're going to need to get with your own attorney, but I'm sure happy to give some general information. And like Stacy said, I'm going to try to take questions as we can at the end of the program if you'll type those in the chat box. Okay, so we're going to kick things off with kind of the basic overview of landowner liability law in Texas. Nobody panic, okay? The first slide is going to be pretty law school-y. After this, we're going to get real practical. And we're going to talk about 5 ways you can today protect your operation from the threat of liability for injuries on your property. Okay, so the way the law works basically when it comes to landowner liability is there are 2 types of potential legal claims a person could make if they're injured on your land. And that's whether it's land that you own or land that you're leasing, okay? And so let's say somebody gets injured, they're going to look at making one of these 2 claims. The first option is called negligent act, and the second is called premises liability. Now, a negligent act claim comes about when there was some sort of ongoing activity on the property that caused the injury. Premises liability claims arise when there was a condition on the land that caused the injury. Okay, and it matters because there's different things that have to be proven under each of those theories to have a successful claim by an injured plaintiff. Okay, so the example that I like to give for a negligent act is Let's say that you ran someone over with your tractor. That's a negligent act case, right? Because there was an ongoing activity on the property. The court's going to analyze that just like any other negligence case. So just like a car accident case, right? And for negligent acts, the court looks at things and will basically say, is this how a reasonable person would have acted under the circumstances? Very fact specific. You're looking at that reasonableness standard, okay? Where we're going to spend more time today is looking at claims for premises liability, and those are the claims for injuries that occur because of a condition on the land. So let's say someone comes on your property, falls in a hole, breaks their leg. That would be a premises liability claim, right? There was no ongoing activity. It was a condition on the property. And those claims are a little bit more complicated from a legal standpoint, because the way a court will analyze that is the court will say, did the landowner or the person occupying the land, like a tenant, okay, did the landowner meet the level of duty they owed to the plaintiff? In other words, everybody owes a certain responsibility to people that are coming on their land to do certain things, okay? If you meet the required responsibility, you're not liable for an injury. If you fail to meet that level of responsibility, that's potentially where you can be liable, okay? So what we have to know then is what level of responsibility do we owe so we can make sure we meet it, right? It depends on the category of person on the property. So Texas law is going to split people into 3 categories, and a landowner owes a different duty or a different level of responsibility for each of those categories, okay? The first category is a trespasser. For our purposes here, I don't care about purple paint or no trespass signs. For this issue, as far as liability goes, this category is going to be anybody who comes on your property without permission, okay? So anybody that comes on your land without permission, the only duty that you owe is not to intentionally injure them or act with gross negligence. That is a very high standard. In other words, that's good for landowners because it's very difficult for an injured plaintiff to prove intentional acts or gross negligence, okay? Gross negligence has to be something really egregious. Courts will say it has to be something that shows a conscious disregard for human life and is almost shocking to the conscience. Okay, so it's going to be something really, really serious to be able to meet that requirement for a plaintiff. So this should make everybody breathe a little bit easier, okay? So let's use an example. Every spring I get questions from Central Texas, right? My phone starts ringing and the question is this: somebody pulled over on the side of the road, hopped my fence to do what? Take pictures with the bluebonnets, right? And they either got injured or I'm worried that they could get injured. Am I liable? Okay, well, this answers the question for us, right? That person's a trespasser because they're there without your permission, okay? And so long as you don't intentionally injure them or act with gross negligence, you're not liable. All right, so I sometimes will say, if there's a hole and that person falls in and breaks their leg, you're not liable for that. If you shove them in the hole, we have a problem, okay? But short of that, no liability for trespassers. And again, that should be something that lets a landowner breathe a little bit easier for injuries of people who are not permitted to be on the property. Okay, that's our first category of person. Our second category of person is called a licensee. That's going to be somebody who comes on the property for their own benefit. So that's going to be somebody who comes over for dinner. They're a licensee. A person who maybe leases the hunting, but they don't pay, right? You just let them come hunt hogs for free, for example. That's a licensee, okay? So our duty to them is higher, all right? We still can't intentionally injure them. We can never push them in the hole, okay? But now we've got a duty to either warn or make safe dangerous known to the landowner that might not be obvious to the plaintiff. So what does that mean? Let's parse that out, okay? The first thing is we need to think of any dangerous conditions on the property. All right, so I think the classic example, right, is if you've got an old abandoned well on the property, that's potentially going to be a problem, all right, because that's a dangerous condition. It's probably hidden from view. If you know about it, you have to take action to either warn people about it or make it safe. All right, so how do you warn? There's no magic formula. You just need to do something to warn people. So that might look like putting up a sign. It might look like telling people about it. You know the lawyer is going to want you to do that in writing, okay? So maybe if you have a hunting lease, for example, you put in writing, you know, here are dangerous conditions that we know of on the property. So that's the level of duty for a licensee, okay? One question that I get here a lot is, what about snakes, right? So do I have to warn people, hey, there might be rattlesnakes on my property? In Texas, the answer generally is no, okay? There's a rule in Texas that says for wild animals, that's things like snakes, scorpions, spiders, bees, wasps, okay? For wild animals, the general rule is you are not liable for injuries, subject to just a couple of kind of wonky exceptions. Okay, the first exception is if you brought the wild animal in from outside, like you brought it to the land, you can be liable. So I always say, if you have a native Texan rattlesnake, you're good. If you go to the Amazon and bring home a souvenir, you could have a problem, okay? The second exception is you can be liable if you intentionally like gather up the snakes and keep them under your control. Not a problem for me, okay? If you got free range snakes, you're good. All right, and then the third exception that it comes up just from time to time, there was a recent Supreme Court case on it, is if there's an artificial structure on your property and there's a wild animal in the artificial structure, kind of this rule of non-liability doesn't apply. And the question is back to our slide here. Did you know about that dangerous condition? Did you warn the person about it? And was it hidden? Okay, so again, in general, we don't have to worry about things like snakes, scorpions, spiders, wasps. Okay? Our third category of people is called an invitee. That's going to be somebody who enters the property for mutual benefit of themselves and the landowner. So this is going to be like your paid tenants, your UPS man, the plumber, all right? We owe the highest duty to them. So we still can't intentionally injure them. We still have to warn them about hidden dangerous conditions that we're aware of. But now we also have a duty to warn them about hidden dangerous conditions we should know about with a reasonable inspection. Okay, see how that's higher? The question isn't, did the landowner know, but would a reasonable landowner have known with a reasonable inspection? All right? So again, I know that that's law school-y. We're about to get into the practical, but that's sort of how the law works and how a court would go about analyzing a claim if somebody gets injured on your land. All right, who feels like this? No hunting, no fishing, no nothing, go home. Anyone? I feel like after that slide, that's how everybody probably feels on the inside. Don't panic. There are steps that you can take to protect yourself from liability, where you can feel safe opening up your property to people to, come visit, to come hunt, to come do other sorts of activities. And we're going to walk through 5 of those steps today. The first topic that we're going to hit on is liability insurance. And in my mind, this is the place you have to start. If you don't do anything else, you need to have liability insurance, okay? This is true for every landowner and for every tenant. So if you're leasing land to graze your cows, or you're leasing land to, grow wheat or whatever, you need to have liability insurance on that leased property, okay? Here's why. When we think about insurance, everybody kind of understands, right, that we buy insurance, and then if there's a claim that's made that's covered under the policy, they'll pay up to our policy limits. We know that, and obviously that's a benefit. The other benefit of liability insurance that you don't want to overlook is that it also provides you a defense in the event a claim is made. Okay, so what that means is if somebody gets injured out at the North Place where my kids did their video, my first phone call is going to be to my insurance company, and they're going to hire me an attorney on their dime to get me out of that litigation. Okay, that lawyer is going to represent me in a lawsuit, and that's huge, right? The idea that you basically have an attorney on retainer paid for by your insurance company is a huge benefit that liability insurance offers. Okay, and if you look at the cost of having to fight a lawsuit, I worked at a civil litigation firm before I took this job at Texas A&M, and about 10 years ago, my boss would tell people that if you have to take a case to trial, you're looking at $100,000 minimum. Okay, that liability insurance is really important for that purpose alone. All right, the next thing I want to say is I don't care who you get your insurance from. I care that you have it. So there are a lot of great companies that offer insurance. In Texas, we're lucky to have several ag-related companies. There are also a lot of insurance agents who are involved in ag. So maybe if their company isn't, they understand it. Just make sure you have good insurance. Okay. It's really pretty affordable. And you may think, yeah, right, I saw our insurance bill last year. She's crazy. What you probably saw was your entire insurance bill, which would include your property coverage as well as your liability coverage. If you look at the breakdown, the liability coverage is way cheap. It's the property coverage that's expensive. Okay, so just by way of example, we've got a half section here in the Panhandle that we insure for about $500,000. The yearly cost on that is right at $100, right? And so having it pretty affordable. The other thing I would tell you is when you're pricing insurance, always ask about different levels of coverage. Okay, so if you price it at $500,000, per occurrence, also price it at $1 million, because a lot of times you're talking like $10 to go from one coverage level to another, and maybe worth adding additional coverage. All right, so on that note, how much insurance do I need? I'm going to be the lawyer and give you the answer that's not helpful and tell you that it depends. Okay, it really does depend on what you're doing and the different risk levels that you've got in the operation. So, for example, we've got a place where we don't have hunters. It's in the middle of nowhere. All we do is run cows. We have liability insurance. We just don't have a lot of it because our risk isn't that high. All right. Compare that. Last fall, I took my kids to a pumpkin patch, and it was lovely. We had a great time. All I could see was liability pitfalls the entire time, right? Their potential liability, super high. So they need way more coverage than our place kind of in the middle of nowhere where our cows are, all right? And again, that's where you can work with your insurance agent to kind of figure that out. The one thing I will say, and we're going to talk about this in just a minute, is if you're going to have people on your property for recreational purposes, things like hunting, fishing, swimming, riding four-wheelers, if you're going to have those people there, you should at least have the amount of insurance coverage listed in the recreational use statute. Okay, we're going to talk about the recreational use statute in just a minute. I'll give you the numbers and I'll explain why. But just remember, if you've got recreational users, I would have at least that amount of coverage or higher because of that statute that we'll talk about. Okay, another thing on insurance, make sure that everything you have going on is covered. So for example, if you've got a ranch and you've got a good farm and ranch policy, if something happens, somebody on the land hunting or raising, something happens with the cows, you're probably fine. If you start getting further away and doing different things, right? Like you decide to open up a stand on the side of the road to sell products to people on the highway, or you decide to start doing the direct marketing of your beef to the consumer, that's where you're going to need to really talk to that insurance agent, make sure whatever you've got going is covered. And every policy is different, so you need to really make sure you understand what's included in the policy, what exclusions there might be, what endorsements you might need to add. Okay, the last thing I'll say as far as liability coverage goes is watch for any caps on coverage in the fine print. I'll tell you where I see this sometimes on policies here in Texas, and that is on spray drift. So I've seen copies of $1 million liability policies, but if you get reading in the details, there's a cap on the coverage for damages caused by pesticide drift of $25,000, right? So there's a big difference between $25,000 and $1 million. And so if you're somebody who's got that $1 million policy, you're going to be spraying pesticide, you may want to look at getting an endorsement to up that coverage amount, right? You'd pay extra for that, but that may be something that you want to look at. So again, just communicate with your agent, look at the policies, make sure that you understand your coverage. Okay, so that was number one. Number two kind of goes back to that first slide that we talked about, and that is the second thing you can do to sort of protect yourself is to make sure that you meet the duty you owe to people coming on the property. And so what I always say to folks is, listen, if you can make sure that you always identify hidden dangerous conditions and either warn people about them or make them safe, you've met that highest level of duty you owe, and you won't ever be liable. Doesn't mean you won't be sued, right? And that's why we have that insurance. But if you meet that level of duty, you're not going to be liable. So, listen, and I understand, right? In the real world, we're not going out every night at 6 p.m. and inspecting our property to make sure there's not some new hidden danger that we need to warn people about. The law says it needs to be a reasonable inspection. So, one example might be if I've got hunters that are going to show up in September for the opening weekend or November for the opening weekend of deer season, I sure might go out and make a little inspection before the first day and see if there's anything we need to add to our list of, dangerous conditions. So just keep in mind that that also is defense, right? You met that duty. If that's true, you are not liable. So that's another option as well. The third option really deals with people who are coming on the property for recreational activities. Again, things like hunting, fishing, swimming, four-wheelers, anything like that. You may want to look at obtaining a written liability waiver. Okay, sometimes you hear these called liability releases. Same thing, all right? And so I'll get this question. People will say, well, I heard that those liability waivers aren't worth the paper that they're written on. And that's generally not true, okay? So at least in Texas, the general rule is that a court will enforce a liability waiver if it's validly drafted, okay? And if the injured party is an adult. So what that means is, all right, for minor children, okay, so let's say we have a kid who's 15 that comes to hunt. A lot of us will have the parent sign a waiver on behalf of the child. Texas courts, okay, the Supreme Court has never answered this question, but lower level Texas courts have questioned whether or not they will enforce those. And a couple of courts have said no, that we're not going to enforce a liability waiver signed on behalf of a minor, kind of a public policy thing that we don't want to leave injured children without a remedy. Okay, so if you've got kids coming on the property, I still get them. I still get the waiver, have the parent sign it, okay, because I don't know what the Supreme Court thinks about that. In the back of my head, I know it may be iffy, but I think it's worth a try, okay? So like I say, in general, those waivers are enforceable. There's a question about children, I'd still get them, but they have to be validly drafted. Now listen, there are some things in the law that I think you can do yourself. I don't think that you need to pay an attorney to do everything, okay? Liability waivers are tricky enough, and courts interpreting these are picky enough that I do think it's worth using an attorney to draft your waiver, okay? If you use a lawyer who does a lot of these, they've got a form, right? They're going to just make a few tweaks, put your information in. It shouldn't be an outrageous legal bill to get a waiver. The other thing I'll say on waivers is the law on this doesn't change all that often. So likely you can have them draft a waiver for you this year, and then you can use that same waiver year after year. You don't have to go back every year to the lawyer to get a different one drafted. Okay, so I really think that's smart money ahead, because again, it's just another option in your folder of potential defenses if you end up getting sued. Okay, the law on the waiver is kind of twofold. It has to be express and it has to be conspicuous. So what that means is, in Texas, there's something called the express negligence doctrine, which means the waiver actually has to say the words, right? We will not hold the landowner liable for negligence, or we release the landowner from claims for negligence. It has to say words like that. If it were to just say, we won't sue the landowner, that's not good enough, okay? It also needs to be signed at or near the time of the activity. There's no case law on what that means. I'll tell you what I do. I sort of just go with my gut, which is once a year. So if we've got hunters that come every fall, we're going to get a new liability waiver signed each fall, okay? It's also got to be conspicuous. That means don't hide it in the fine print, okay? It needs to be a separate sheet of paper, not on page 7 of your hunting lease, okay? In big, bold letters, it needs to say waiver of liability or release of liability. The reason for that is you don't want someone to come back and say that they didn't know what they were signing, because that's an argument plaintiffs will sometimes make to try to get out of a waiver. Okay, and again, liability waivers, generally we see those when you're dealing with somebody there for a recreational use. You don't hand those out like to employees that are coming to work during the day. That just doesn't work. So just keep those in mind. They're an option. Now, some of you may think to yourselves like, well, look, my neighbor has hunted on me for 30 years and I've never made him sign anything. I'm not starting now. I understand that, because that's what my dad would say, all right? Dealt with this issue. And that's where, look, I'm giving you 5 different options for potential defenses. We only need one to work. And so if there's somebody who's coming and you're thinking, I'm just flat out not going to have them sign a waiver, that's a decision that you can make, okay? And there are other defenses you can rely on, okay? Things like warning them of dangerous conditions, things like the recreational use statute and the agritourism act, okay? We're going to talk about those. And at the end of the day, the backstop is always, you've got liability insurance for a reason, okay? So like I say, I'm not saying that you have to do all 5 of these. The paranoid lawyer in me wants you to. But the real key here is just to have at least one of these options that will apply in your situation to get you dismissed out of the case. Okay, our 4th step is something that you can consider, and that is the use of a business entity to limit your liability. Okay, so the way this works is there are certain business entities you can set up that offer limited liability to the members or participants. Generally, you see that with a limited liability company, corporations, trusts, to a certain extent, limited partnerships. Okay, and so just by way of example, here's how that would work. Let's say that I own my ranch in my name, right? Tiffany owns the ranch, and someone out there gets injured, and they sue me. Okay, they can go after the assets of the ranch, but they could also come after my personal assets, right? My investment accounts, my personal, assets that are mine, that don't relate at all to the ranch, all right? What you can do with a business entity, like an LLC, for example, is you can set up the LLC to actually own the ranch. So I would have to go in and deed the ranch to Tiffany LLC, okay? It's the owner now. I don't own it anymore personally, okay? I might be the only managing member of the LLC, but personally, I don't own that ranch. And if somebody gets injured now, they can go after the assets of the LLC, but my personal assets are protected, right? So that's how that works. Sometimes you'll see people that use multiple entities. An example of that, there's a family here in the Panhandle that has a family farm and a custom harvest business, right? They've got one LLC for the family farm. They've got another for a custom harvest business. Okay, and the reason for that is, look, driving combines up and down the highway is dangerous. And if something happens with one of those combines, the assets of that business may be at risk, but their family farm assets, their personal assets are shielded because of the business entity. Okay, so that's how that works. A couple things to note here. The first one is which business entity works best for you, and whether or not you even want to look at one is really going to depend on your operation. And this is where I would talk with an attorney. Maybe more importantly, or as important at least, I would talk to my accountant, because there can certainly be some tax implications here depending on which entity you choose and what your operation looks like. So certainly before you do this, you need to talk with an attorney, talk with an accountant, because there may be other considerations that make you think, it's not worth you getting a business entity, right? The limited liability is a pro in the pro column for an entity. There may be cons that outweigh that, and you don't want to do it. So you sure want to look into that. If you're going to use a business entity, it's really critical that you jump through the right hoops to get the protections. So if you're going to set up an entity, there are certain things that you have to do. Things like deeding the assets into that entity, keeping separate bank accounts, doing what any corporate documents say you're going to do. If it's, you got to have an annual meeting, you got to have it, okay? So to get that protection and to avoid someone being able to, they call it pierce the corporate shield and get to those personal assets, you've got to actually kind of keep the formalities that the entity requires, okay? If you want more info on business entities, I've got a podcast. I'll show you how to find that at the end of the program. But I did one with Amber Miller, who's a lawyer up in Lubbock, all about the different kinds of business entities, how to set them up, some of the pros and cons for people in agriculture. You can listen to that for free on the internet, again, on my podcast page. I'll show you where to find that at the end of the program. Okay, our fifth step is actually three things, but that is you want to make sure that you're aware of and try to comply with the 3 limited liability statutes that exist here in Texas. Okay, there's the Texas Recreational Use Statute, the Texas Agritourism Act, and the Texas Farm Animal Liability Act. These 3 statutes, okay, were the legislature's attempt at offering some protection to ag landowners who open up their property to people to come out and do certain activities. Essentially, it's free limited liability. It kind of changes the analysis of that first slide in the landowner's favor, okay? These are really important, guys, and if you've got, people coming out for the activities we're going to talk about, you need to make sure that these apply. The first statute's my favorite. It's called the Recreational Use Statutes, and we're going to try to go fairly quickly through this just for the sake of time. But essentially what the Recreational Use Statute says is that landowners are liable only for intentional acts or gross negligence if they meet the 3 statutory requirements. All right? Now, that should ring a bell to you. Liable only for intentional acts or gross negligence. That's the trespasser standard. Okay? Remember how we talked about this was a high burden, hard for plaintiffs to prove? This statute's going to let you treat people coming on your property, even with permission, even if they paid you, as a trespasser for liability purposes. All right? This is super, super landowner friendly. Okay, so here are our 3 requirements. The first requirement is it needs to be agricultural land. There are pieces of this that apply to non-ag land, but we're not going to get into that, okay? So, number 1, agricultural land. The statute says that is land that is suitable for growing crops, raising livestock, or forestry, right? That says suitable for. You don't have to actually be doing one of those things. And I do not care what the appraisal district says, okay? That's a pretty broad definition. What I always think to myself is, so anywhere that it would be suitable for me to raise goats is ag land. And I feel like goats can kind of live anywhere, all right? So pretty broad definition, all right? So that's our first requirement, ag land. The second requirement is the plaintiff, the person who was injured, had to be there for a recreational purpose. there's a big list in the statute that tells us what those are. Hunting is the first thing listed. I get the most questions on that. Hunting, fishing, swimming, boating, four-wheelers, picnicking, hiking, nature walks, and then it says, and anything else associated with enjoying nature or the outdoors. So again, pretty broad, okay? One limitation we do have on that from case law is courts have said that this does not apply if the person was injured while attending an outdoor wedding, okay? So if we think about like the wedding barns that we have popping up all over the place, if the attendee of the wedding was injured, courts said that is not a recreational activity, okay? So we have ag land. The plaintiff was there for a recreational purpose, okay? And then you've got to meet one of the next three monetary options. So you see the kind of gold colored bullets there. You got to meet at least one of those three. Only one's required. The first option is if you do not charge a fee. So if you're my dad, you let your neighbor come hunt for free. That means the recreational use statute applies. You essentially get to treat him like a trespasser for liability purposes, and you're not liable unless there's an intentional act or gross negligence. Okay? That's a big deal. And you don't have to do anything else. There's no signs to hang up. There's no waivers to have to sign. It just automatically applies. All right? That's your first option if you don't charge a fee. There's an option here if you are going to charge people to come. And that says if the total charges collected for the past calendar year are not more than 20 times the total amount of ad valorem taxes imposed on the premises for the previous calendar year. In English, what that says is, get a pencil. You need to look at 2019 and add up all the money you made from recreational users. Right? That's anybody who came and paid you to hunt, fish, hike, whatever. Get a total. Then you need to get another column and add up all the property taxes you paid anywhere in Texas. Okay? Not just where you have your hunters, even if you've got a fancy house in Austin, all the property taxes you paid, get a total. As long as the income number is not 20 times higher than the taxes, the statute applies. Okay? And again, you get to treat those people like trespassers. Okay, that most people fit there. You've got to make a lot of money from hunting for that not to work. Okay? And then you have a third option. The third option is if you have liability insurance coverage of at least $500,000 per person, $1 million per occurrence, and $100,000 for property damage. If you have that level of insurance or higher, the statute applies. We don't care what you charge. And as an added bonus, the statute will act as a cap on your damages, meaning that the plaintiff can't recover more than your insurance limits. That's a big deal, okay? And that's why earlier I told you, if you're gonna have recreational users on your property, you want that level of insurance or higher because of that cap, okay? That's the entire statute. There's no list of exceptions. There's no other requirements. For my money, that's the best statute in Texas, all right? So if you've got recreational users, try to make sure that that one applies. Okay, our second statute is newer, and that's called the Texas Agritourism Act. When it first came out, I thought, well, I don't have a pumpkin patch, so I don't really care that much about this. And then I read the statute, and gosh, guys, the way it's written, I think it applies to all of our ranches and farms here in Texas. What it says is an agritourism entity is not liable if the injured person was there for a recreational or educational purpose, and you either hung up a sign or got a specific release from that plaintiff. Okay? So what is an agritourism entity? The statute says that's a person engaged in providing an educational or recreational activity on agricultural land, regardless of compensation. Okay? Agricultural land is defined as land that is suitable for growing crops, raising livestock. Okay, suitable for, really broad. Recreational event, same definition as the recreational use statute, hunting, fishing, hiking, yada, yada. Okay, it also applies to educational activities. So let's say that your county agent wants to have a field day at your place. This statute could protect you, right? Because here's an educational event on agricultural land. Now, to get the protection, you're going to have to hang up a sign or get an Agritourism Act waiver. Okay, so let's look at those. The sign is the one that we have hanging up at our place that my kids were talking about at the video at the beginning. Okay, it's got to be posted at a clearly visible location on or near the premises where the activity is conducted. There's the language. I just copied and pasted that right from the statutes. Okay, you can make your own sign. There's a number of groups that sell them, TSCRA included. I think they've got a couple options. They've got the kind of blue plastic signs. They've got the fancier ones. I don't know what they're made of, but they almost look like glass. They're really thick. Other groups sell them as well. Doesn't matter who you get them from. Doesn't matter if you make it yourself, but get your sign hung up. Where do you hang it? I think it, again, it depends kind of on what you're doing. If you've got hunters, I always tell people to hang them at the gates because they're gonna have to come through a gate theoretically. If you've got a swimming hole, I'd post it by the swimming hole. Okay. So that's one option, is to hang up a sign. The other options, you can have them sign the Agritourism Act release. Okay, and again, I'm just copying and pasting this language. It's got to be signed before the activity by the participants or their parent, guardian, or managing conservator. It needs to be separate than any other document, so don't put it in your hunting lease, separate sheet of paper, and you've got to print it in at least 10-point bold font. I don't know. Okay, that's what the statute says. And again, here's the language. I copied and pasted. You just have them sign that waiver. You can choose. Either one will get you the protection, either the sign or the waiver. I like things about both, okay? I like the sign because it, oh good, Stacy's put a link to where you can find those and purchase them from TSCRA. Okay, I like the sign because you just hang it up and forget about it. So that's why we have one on our gate, okay? The one place I like the waiver better is if you're gonna have minor children on the property, okay? Remember what we said at the beginning. If you've got minor children on the property, that regular old liability waiver may or may not be enforceable. But if you look at the Agritourism Act, look at that second bullet. The legislature said this waiver could be signed by the participant or their parent, guardian, or managing conservator. That looks like pretty good evidence to me that the legislature intended this waiver to waive claims for minor children. All right, so if you're gonna let kids under 18 come out for recreational or educational events, I would want the waiver, okay? I'm extra paranoid, right? Law school trained me for that. I would hang up the sign too, right? But the waiver is a good option, especially for minor children. Okay, the last thing on the Agritourism Act, there's a list of exceptions. We don't have any case law on these yet because it's a fairly new statute. What I would tell you is this: spend the, whatever it is, $10 and hang up the sign. Let the lawyers fight about the exceptions, okay? Hang up the sign, at least that's an option. Okay, our final statute that we're gonna cover is the Texas Farm Animal Liability Act. This used to be called the Texas Equine Act, but they changed it in about 2011, I think, to make it broader, where it applies to more than just equine animals. It applies also to like cattle, sheep, goats, pigs, chickens, okay? So the requirements for the Farm Animal Liability Act, what the statute says is that people are not liable for damages to a participant in a farm animal activity or a livestock show if the injury results from risks inherent to that activity. In other words, the legislature basically said, we know that there are certain inherent risks if you're going to deal with farm animals, and we're not going to have the owner of the animal be liable if the injury was caused by an inherent risk. Okay? classic example is if somebody gets bucked off a horse, that's probably an inherent risk of riding a horse, okay? And that's where the owner of the horse would raise the Farm Animal Liability Act as a defense, all right, and try to get the case dismissed, all right? Now, for the Farm Animal Liability Act, there's a list of inherent risks. The first one, I think, basically covers everything. It says the propensity of an animal to behave in ways that may result in injury. So I feel like almost any animal injury could sort of fall under that. The next thing I'll say is for the statute to apply, if you're a regular person like me, right, who just owns farm animals, right, we have horses, we have a pony, we have cows, we have sheep. I don't have to hang up a sign. The statute just automatically protects me. But if you're a farm animal professional, then you're going to have to hang up the sign in order for the statute to apply. And a farm animal professional is a person engaged for compensation in instructing a participant or renting to them an animal, equipment, or tack, or who provides veterinary or farrier services. All right, so let's say you're giving riding lessons or you're renting out animals for people to go on trail rides or something. You're going to have to hang up the sign, okay? And this language also needs to be in any of your contracts. Again, I copied and pasted that language. You can buy those signs. I know Texas Farm Bureau has them. TSCRA may have them. Stacy, if so, I'll let you put a link in the chat. But that's how it works for farm animal professionals. Okay, there's a different sign you need to have if you're a livestock show sponsor. And so if anybody's on your county stock show board, use this sign to hang up at your events. Same for rodeos, horse shows, barrel races. There's a list of exceptions under the Farm Animal Liability Act. For time purposes, I only want to talk about this one that's in bold. Okay, and so here's how this works. So the Farm Animal Liability Act is a defense, right? If somebody gets injured, the owner of the animal says, Farm Animal Liability Act applies, dismiss the case. If a plaintiff can then prove that one of the exceptions applies, the case gets to go forward. And so the one exception that I think gives me some heartburn, right, is a case can go forward if a defendant provided an animal to the person and did not make a reasonable and prudent effort to determine the ability of the participant to safely engage in the activity and to safely manage the animal. Okay, so for example, if somebody comes over and you stick them on a horse, you better ask some questions, right, about how many times they've ridden. You know, do they own a horse? You may want to let them, you know, go around in the corral a few times to make sure they actually know what they're doing, right, to get the protections. So just be aware of that. Okay, we're going to skip the James versus Young case just for the sake of time. If you want to read about that, you can find it on my blog. I'll show you where to go to get that. You can just search James versus Young. I'm going to skip my really funny joke about my kid and her pony. Okay, so wrapping up from me, and then I'm going to get into the questions. We've got quite a few of those. I'm going to do my best to answer as many as we can. Stacy has said we can go a little bit over time, so we'll do what we can. The first thing I'll mention is I've got a couple of other programs that I do if you're interested in agricultural law that are scheduled for the fall. The first list you'll see there is called Owning Your Piece of Texas. It's a day-long ag law program where we try to cover some of the top laws that landowners need to know. It's $75. We will feed you lunch and give you a copy of our Owning Your Piece of Texas handbook. You can see the locations and dates there. We also, that says 2019, it should say 2020, have a series of ranchers leasing workshops that we do. Those are half-day programs. We will feed you lunch at those as well. Give you a copy of our leasing handbook, and it's a half-day talking about legal and economic issues related to leasing. If you're interested in those, contact me, or you can go to that website there to get more info. I mentioned our Owning Your Piece of Texas handbook. If you're a Texas landowner and you're interested in ag law, this is just a handbook that has about 14 or 15 chapters that addresses different issues you may want to be aware of. If you want a hard copy, we charge for those, and you can call that phone number there at the top. If you just want an electronic copy, a PDF, You can download it for free on my blog. And again, I'm going to show you on the next slide how to do that. Okay, this is my Texas Agriculture Law blog. This is where I'll post everything that I do. So once a week, I've got a post about different ag law issues, whether that's a checklist or a handbook or info on a case that just happens. So feel free to check that out if you would like to. There's the website address, or you can Google it. If you subscribe, my post will come to you like an email from me. You'll see a little tab here that says Published Materials. That's where you can download those handbooks I mentioned for free, okay? You've got that. I've got a podcast as well. It's where I interview someone on various ag law issues every episode. We've covered everything you can think of. I think we're on episode 70 now. You can listen on your favorite podcast app or on iTunes, Apple, Google Play, or you can just go to that website right there on the screen, aglaw.libsyn.com. All you've got to do is pick the one you want and push the play button. Okay, the last slide here is my contact information. Email right now is for sure the best way to get a hold of me because of the COVID situation. I'm working at home. So email me. There's also, I'm on social media, the blog, and the podcast. Okay, so with that, let's jump into questions. And I will tell you that as we go, if you have questions after this, shoot me an email, okay? And I'm super happy to answer any questions that we may not get to here today. Okay, one question, oh, this is interesting, from Gary. Gary says he has a cow-calf operation, but he also teaches scuba diving in his pool on the residence. Would scuba training fall under the provisions of the recreational use statute? I've never seen a case on that, Gary. Most of us aren't scuba diving in our stock tanks. I don't think so. And the reason is this.
I teach you scuba diving.
Sell that an in-ground pool is on agricultural land. If you were diving like in a, I would call it like a dirt tank, you might call it a pond, that's like ag in nature and the cows are drinking out of it, maybe we could sell that. Seems like a harder sell to me if you've got like a legit in-ground swimming pool. So I don't think so, but listen, it doesn't hurt to have that recreational use protection anyway, have that level of insurance coverage, and you're
Not much.
both that if that
Our renter's moving out. Single. You know, she's
Dishes.
always had her rent to me early, you know. And I thought, well,
I
today's
can
the
hear somebody talking.
She
Oh,
has-
that's my mother. Mom, we can hear you. Shh. Sorry. Okay. The next thing that we'll say is the presence of a fault. Mom, you can't talk. Okay. The presence of a falling down barn. What is the liability for that? On the one hand, right, that's not a hidden condition. Anyone could see it. Strikes me as being pretty obvious. I'm probably not going to lose too much sleep over that. You could certainly warn people about it. That's one that probably isn't going to be a huge issue. Again, especially if it's a trespasser, I don't think it's going to be considered gross negligence to have an older barn. So wouldn't lose too much sleep there. Rex, thank you for your kind comment. I appreciate that. Okay, Donald asked a question. He read an article recently about state versus county stock laws and the impact on liability for cows on the road. Absolutely, Donald, huge issue. Fence law is one of my favorite topics. The quick overview of that, I'll give you. The other thing I'll say is in that handbook I mentioned, there's a whole chapter on fence law. And if you will go and look at that, you can get more details there. Okay. So the general rule in Texas is that we're an open range state, which means that landowners do not have an obligation to keep their livestock fenced in, right? In other words, it's a fence out state where people have to actually fence them off of their property. That's the general rule. There are two ways that can be changed. And actually in Texas, a lot of times those have been changed and much of the state is closed range now. Okay, so if it's closed range, there is an obligation on that landowner to fence the animal in. There's two ways that can happen. The first is the state statute that says all state and U.S. highways are closed range. Okay, so that means if you're on a state or U.S. highway that is not a farm to market road. That's going to be like I-40 or Highway 287, Highway 6. Okay. State and U.S. highways are all closed range, and a landowner can be liable if their animals get hit on those roads if they knowingly permitted them to run at large. Okay, that's a state statute. County-wise, each county has the ability to have an election and change all or part of that county from open range to closed range. Okay, so that means if you have a local election in your county, you could say we're going to be closed range, and now a landowner can be liable if they permit their animals to run at large. Okay, so that's sort of how that works. I know that's the quick answer. That's the difference. What I would tell you on a practical level is I would look at your county where your animals are located and figure out if there is a local stock law. Start with your county extension agents. Hopefully they know, because I've been harassing them to get me the answers. You can also check with your county attorney, county judge, county clerk. Where you would find them is in the commissioner court records. And a lot of them were held back in 1900, so it can be hard to find. But that's the answer to that. Okay, Edward asked a question about umbrella liability policy. Is there a specific endorsement that there should be, or commercial umbrella to protect the landowner? There's not really anything specific. An umbrella policy is a great option to increase the dollar amount of coverage that you have on your policy. So, for example, I might have a $500,000 liability policy and then buy a $2 million umbrella. What that does is just increases my dollar amount of coverage, usually for pretty cheap. It's not that expensive to buy an umbrella policy. What it does not do, keep this in mind, it does not expand the scope of your coverage beyond that which you already had with your base policy. So sometimes people will say, well, I have an umbrella policy. I don't have to, I'm covered for everything. That's not accurate. Okay, if you have an umbrella policy, you're covered for what your policy is written for, plus additional money, not additional scope in coverage. So, and again, as far as how much or the specific types you need to have, that's where you want to visit with your insurance agent on that. Okay, let's see. Can the agritourism waiver be included with a liability release? Jim, the statutory language makes me think the answer to that is yes, because it says it can be included with another limitation of liability. So I think that you can. Must everyone's name be included on the act waiver? Example, a parent signs for the child. Does he have to sign separately for him and the child? I would have that. If you're going to have dad sign the waiver for the son and the dad, I would have the dad sign it and then the dad sign it on behalf of the son. Just because you're two different things there, you don't want a little technicality to bite us. So that's what I would do on that. Richard, I'm setting up an LLC for my land and ranch operations. Do you have any examples of actions that will void the LLC liability protections, pierce the veil? How easy is it to pierce the veil? Truthfully, Richard, as long as you're doing what you're supposed to be doing, it should not be that easy to pierce the corporate veil. Again, that's things like, you know, you've got to file your articles of incorporations, make sure you transfer the assets you want protected into the LLC. You probably ought to have an operating agreement for the LLC, separate bank accounts. It's not a huge ordeal to jump through to get that protection. As long as you do those things, kind of check those boxes. I'm not going to say it could never happen, but in general, that's a pretty good way to protect yourself. Okay, PJ asked for a copy of the slides. Absolutely. Stacy, I don't know, when you send out the recording, if you can send out a copy of the slides?
I can send out a link to them. So if you want to send me a PDF, we can certainly do that.
Glad to do it. Yeah, so I'll send. Yeah, I'll send that PDF to Stacy. You guys can download those from her. If for some reason you don't get that, shoot me an email and I will send them to you. Okay, Eric, would negligence be setting up boards with nails to stop people from mudding or destroying crops on the property? Maybe. Yeah, Eric, that one makes me a little bit antsy, because that is something intentional you're doing. Boards with probably hidden. I might try to find some other way to try to keep people off the property. That makes me a little bit nervous, if that's something you were doing. I had somebody else ask one time, they had people that kept like running off the road through their fence, and they wanted to put like a big concrete berm. That one made me a little bit antsy too, because like you could probably kill somebody like that. So I'd be a little bit careful with that. Okay, we have someone anonymous ask the question, what if an animal jumps or gets out of your fence premises and wanders a couple away from your property and gets hit by a car? Is animal liability the only way to cover that risk? Good question. If you have liability insurance for your property, that should cover your animal, even if it gets out and gets hit 2 properties away. Okay, it's liability insurance that you would have. Make sure that your liability insurance covers livestock getting out on the roadway. They're not going to pay you for the cows, okay? But it would cover damages caused by your livestock on the road. And there are some policies that don't have that. I know somebody who just got in a situation where something got hit. They didn't have insurance coverage for livestock on the road. That was a bad mistake, okay? So now, if you wanted coverage to pay you for the value of the dead animal, that's not liability coverage. It won't do that. What it would do is it would pay, you would have to have livestock mortality coverage on the animal. And that's something you can buy. A lot of times you'll see that with like high dollar seed stock bulls or sometimes show steers. I've seen people get it. It's fairly pricey. But that is an option if you want coverage on the animal. The liability insurance would not cover that. Okay. Okay, here's a question. What additional or special liability does a utility easement bring to the landowner who's leased the grass to another? Okay, so Seth, if you own your property, there's a utility easement across it, and you've leased your grass to somebody else. Hopefully, in your easement agreement, there is a liability and an indemnification clause that would say that you're not liable for the acts of the people coming on the easement, right? So let's say it's an oil and gas company. You're not liable for their employees and their actions, and usually vice versa. So hopefully that there's that in the agreement. I would certainly, in a lease like that, I would make sure that the grass lessee is aware that there's a utility easement so that they know there's a potential issue there. I'll be honest with you, I get questions on this sometimes. I've never seen a case where there was a huge issue, so hopefully that's a good sign where we wouldn't have major issues there. Again, that's where liability insurance probably comes into play. You can have those provisions to protect yourself in the lease. Hopefully you've got good provisions in that easement, but you've got liability insurance as well. Okay, here's a question. We need to have a fence law webinar, Stacy. That's what we're learning in these questions. If cattle from my neighbor's land end up on my property and have caused damage to my land, trees and crops, what is my recourse? There's a fence, but it's in poor condition and the cattle are jumping in at weak points. Okay, the answer to that question is going to depend on whether you're in an open range or a closed range county, okay, and area in the county, okay? So if we are in an open range county, right, there's no local stock law, the obligation then is on you as the neighbor to fence the cattle out. So in an open range county, the neighbor has to fence them out. If it's a closed range county, okay, now the owner of the cattle has the obligation to fence them in. So in a closed range county, it's the opposite, right? The cattle owner needs to take care of that fence and make sure that it's up to snuff. So you're going to need to figure out, are you in an open range or a closed range county? And that tells you whose obligation it is, okay? Even if you're in an open range county where you as the neighbor have the obligation to fence them out, you need to look at our little handbook that we have, because there's a statute that talks about sufficient fences in the handbook, okay? And if you have a sufficient fence and they're still getting in an open range area, it's possible that you're not liable, the owner is. And the sufficient fence is pretty minimal. For a barbed wire fence, I think it only has to be like a 3-strand. So figure out if you're in open or closed range area. If it's open range, take a look at that statute to see if you might still be able to put that obligation on the landowner. Okay. I saw a question here. Oh, I don't know the answer, Chad. Chad says that there have been people speeding, using the right-of-way on our property to speed. What type of impediments can be used to slow them down? I don't know the answer to that. I'm sorry. I would be careful there. Might be a better option to try to talk to law enforcement, see if you could get them to do something. From a liability perspective, that makes me a little bit sweaty. Okay. Okay, Susan. When you saw knowingly permitted them to run at large, does that mean you must have knowledge that they were out? If they got out and you didn't know, are you permitting them to run at large? Susan, great question. I've got lots of blog posts on that where we've looked at the cases. So when you're looking at closed range, okay, if they got out and got hit on a state or US highway, the question is, did you knowingly permit them to run at large? If it's they got out in a county where there was a stop law and like got hit on a farm to market road, the question is, did you permit them to run at large? There are two standards that are different, not hugely so, but a little different, okay? It's harder for a plaintiff to prove knowingly permit on a state or US highway. What courts will look at are very factual questions there. Things like, did you know they were out? How fast did you act after you found out they were out? What was the quality of your fences? How often had they been out before? Did you leave the gate open? Okay, all of those things are very factual. A court will look at those to determine if you knowingly permitted or permitted them to run at large. Very few cases have addressed that issue and found someone to knowingly permit them to run at large. One example that I can think of is there was a case where the guy knew that his cattle got out when there were big rains. There was a big rain that day. He didn't go check on anything. He got a call that night the cattle were out, didn't go get them in. They got hit the next morning. That's where the court said knowingly permitted. Okay, so I hope that helps. It's very factual. Check out that handbook if you want to read more about those cases. Okay, John says you're 2 miles from a state highway along a county dirt road. A cow gets out, travels to the state highway. Are we liable? That's gonna, okay, so the question's always gonna be where the accident occurred, not where the cow started, okay? So if it's a state highway, the cow went 2 miles, she gets hit on the state highway. The question's gonna be, John, did you knowingly permit that cow to run at large? Okay, and that's the factors we just talked about with Susan. So you're not automatically liable. They're gonna look at those factual issues and come up with the answer. Oh, we're running out of time and you guys keep coming. Okay, I share a mile of barbed wire fence with my neighbor. I can't get the neighbor to invest 50% and redo the fences. My bulls sometimes get over to his cows. Do I have liability if my bulls impregnate his cows? Yeah, potentially. The issue there, again, it's gonna come back to, I keep saying this, are you open range or closed range? If you're an open range county, it's his obligation to fence your bulls out, or at least have that sufficient fence. If it's a closed range county, it's your obligation to fence them in. If they get out and impregnate his cows, and you're closed range and you did not fence them in, there is potential liability there. So you certainly want to look at that. If A neighbor has dead trees from a forest fire and damaged my cattle fence. Is there any liability for damage caused by fallen trees? John, you will be, I got some helpers arriving. You will be shocked, John, to know that there are very few cases in Texas that address that issue. The answer, best I can tell, is if it falls on the neighbor's property, the question is going to be, did they have knowledge that there was likely to be an issue? So, right, if randomly a tree falls, lightning strikes it, it hits the fence, probably not. If there was this old tree that they kind of knew about, potentially. I'll tell you, John, watch my blog, because I've got a post coming on that. My hero of a law student is researching that as we speak, and we'll try to get us some more information on it. I have a contractor who's hired to do work on my property. Do I still need insurance for his workers? I'm operating under an LLC at this time. Vernon, there's a statute in the Civil Practice and Remedies Code that talks about how you're generally not liable for an independent contractor on your property, as long as he truly is an independent contractor and not a employee. Look, I would still have liability insurance because, like we talked about, if something happens, you want to make sure that you have it. There are some additional protections there, I think. You've got the LLC. There's that Civil Practice and Remedies Code. If you want to Google it, it's Chapter 95. You can look at that info as well. Okay, Stacy, I think I got all of them, or at least tried to hit them. If you have more questions, we're out of time. Please contact me by email. I'm sure happy to try to help however I can.
All right. Well, thank you so much, Tiffany, and hello to your helper there.
Yes, Harper Stacy says hi.
Yes. Hi, Harper. But anyway, thank you all for being on today. As we talked about earlier, we will send out the recording as well as the copy of the slides. But thank you all for being on. Thank you, Tiffany, for a very informative program. And I will take you up on that fence law webinar if you have some willingness to do that, because I agree we had a lot of questions around that topic today. So thank you all for being so engaging with us and asking those questions. Those really add to these presentations, and so I certainly thank you for doing that. And with that, we will see you next time, and have a great afternoon.